Good afternoon. My name is Christopher DiOrio, and this is ChrisChat 14. I am an attorney and a civil rights and constitutional law professor, and I do these ChrisChats to answer certain questions, address certain issues that come up regarding the law, sometimes constitutional, sometimes otherwise. But the idea here, as always, is to educate, to not necessarily take a position on certain things. Some questions, however, you wind up going down that road of taking a position. So I want to try to avoid that if possible, because the goal here is to educate. But if you do have questions during the process, of course, I will attempt to answer them. The word impeachment has come up on a regular basis, on a daily basis, on social media, in print media, in conventional media, television, etc. And I think it's important now. You see petitions online. Let's send letters. Let's do this blog. Let's pray for the impeachment of the president. And it seems easy because people have an opinion about the person, that he is. That he's a reprehensible person, that he's acting in a criminal fashion, that he's doing certain things that address the basest parts of what we deem to be correct in terms of our politics. Why can't this happen? Why aren't people moving to impeach this man? First, far too many folks, it seems to me, don't realize that impeachment does not automatically mean that somebody is removed from office. Impeachment is simply a step in the process of this. And as to, I want to talk about the process, when impeachment might be warranted, how to go through the process of impeachment, and then at the end, the whys on impeachment, and maybe more importantly, the why nots. In terms of impeachment. So here goes. And the first question you have to look at here, as always when I look at these things, is what is the constitutional authority for impeachment? Article 1, Section 2 of the U.S. Constitution gives the House of Representatives the sole power of impeachment. Where do we find this? Well, we find this in our handy-dandy pocket constitutions. And once again, if you do not have one, message me and I will send one to you free of charge. This is the essential rule book, and it's important to have these rules here. So as I said, Article 1, Section 2 of the U.S. Constitution gives the House of Representatives the sole power of impeachment. Now, this sole power says that this is where the formal charges against the president in an impeachment case would be levied. Article 1, Section 3 of the Constitution gives the United States Senate the sole power to try all of these impeachments. So most of this happens in the legislative branch of the government, and we'll see why that's important as we get to the end. Article 2, Section 4, however, more importantly here, sets out the legal standard of what constitutes or what can lead to impeachment. So this is when an impeachment might be appropriate. Article 2, Section 4 says as follows: the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So there's a lot of juice in there that we want to juice later on. So therefore, the operative standard, the legal standard to apply to an impeachment of a sitting president is, did they commit treason? Did they engage in bribery? Or have they engaged in what we call high crimes and misdemeanors? So before you even look at the steps of how to impeach someone, in this case, a president, first you have to answer a question. How do you define what high crimes and misdemeanors are? How do you define treason? How do you define bribery? Some people believe that it requires that the subject has committed an indictable crime, something serious. Still others think that what was done by the individual sought to be impeached must in some way relate to the president's official duties. What we know from the attempt to impeach Richard Nixon in 1974 and the almost impeachment of President Clinton in 1996 through 98 is this. Frankly, an impeachable offense is whatever a majority of the House of Representatives considers to be an impeachable offense at that given moment in history. So again, when we get to the end, you'll see that this is kind of the rip in the seam. So as I said, the Constitution sets specific grounds for impeachment: treason, bribery, and other high crimes and misdemeanors. So in order to be impeached and removed, the House and the Senate must find that the official committed one of these acts. So again, looking at high crimes, you have to understand what high means. I'm parsing all of these things out, and I think it's important that you do that. High crimes does not mean more serious. High crimes, in definition, taking this from English common law, refers to punishable offenses that apply to high persons, not high in the common sense, but high persons meaning people who are public officials, people who are entrusted with public authority, people we've elected or appointed to high governmental offices. When we look at what they've done in the capacity of their job, that's what is more considered a high crime. It's not the offense itself, it's who did the offense. So there are things that a person out in the world might do that would not necessarily be felonious, but they might be considered to be impeachable because of who did it. People who, because of their official status, are under special obligations that ordinary Joes like you and me are not under. So high crimes doesn't necessarily apply to us, and these are just punishments for them, if not necessarily for ordinary people. So let's look at the three things that the Constitution specifically provides as being grounds for impeachment. First, treason. The Constitution, thankfully, does in fact define what treason is. In Article 3, Section 3, in the judicial branch, the article dealing with the judicial branch, they lay out what constitutes treason. Says very specifically that treason against the United States shall consist only, so that means it's putting a box around these things. You can't add things in. Shall consist only in levying war against the United States, that's treason, or in adhering to the enemies of the United States, giving them aid and comfort, that no person shall be convicted of treason unless on the testimony of two witnesses to that act or upon confession in open court. So now you have to look at these things and wonder, is what this individual that you're trying to impeach, have they in fact levied war against the United States? Have they adhered to their enemies? Or are you giving aid and comfort to your enemies? And what's crucial here is these enemies are not necessarily enemy states that we don't like. Enemies means we are at war with them. So just because right now people are looking at Russia and saying that this president may or may not have done something in relation to conduct with Russia, we are not at war with Russia. And so they are not technically, as far as the Constitution is concerned, an enemy. So what he does with Russia, or what he may have done with Russia, does not necessarily constitute treason automatically because they are not considered an enemy state for purposes of the constitutional definition of treason. Let's move along. Bribery. What's bribery? The Constitution doesn't define bribery for us, but we know in common law and in subsequent statutory law what bribery is. It comes from English and common law, and it takes place when a person gives an official, an elected official, an appointed official, money or gifts to influence their official behavior in office. For example, if a defendant, in my profession, if a defendant were to give a judge, a federal judge for purposes of constitutional argument, if they were to give a federal judge $10,000 to find someone not guilty, that's bribery. That's affecting the individual's authority and what their decision might be because you've given them remuneration. So that's what bribery is. Now you have to look at what the conduct of the individual that you're seeking to impeach is. Did they take money and did that money then influence their decision? Or did they do the opposite? Did they give somebody else money in an effort to influence their decision? That's bribery. Now you got to look at that third part, and that's the confusing one. what are high crimes and misdemeanors? In order to better understand the meaning of the phrase, you have to understand where it came from and why it's here. In the Constitutional Convention in 1787, the framers of the Constitution, the framers of our government, wanted to create a stronger centralized government, but they didn't want it to be too strong. So they had to create a balance. That's why we have checks and balances. The executive, judicial, and legislative branch, they check each other in that separation of powers. We've talked about this a while before. Congress can propose laws. The president can veto those. The Supreme Court can say that something's unconstitutional. This checks and balances system works. We've had impeachments in the past, or attempted impeachments, 18 times in 227 years of our collective existence as the United States. We've only had 18 impeachments. 13 of them have been for federal judges. Impeachment of judges was overwhelmingly supported by the founders because they felt that because they had lifetime appointments, as federal judges do, there had to be some direct check on their power. When it came to impeachment for executive officials, like the president, like the vice president, and so on, there was an argument that we shouldn't have impeachment because, frankly, that's what the elections are for. We have a check on the authority of the president. Every 4 years, we have an election. We can vote them out. James Madison, however, successfully argued that elections every 4 years wasn't enough of a check. That if there is a president who is incapacitated or abusing the power of office, that loss of capacity or corruption or some other types of engagements by the president or the executive might be fatal to the republic if there wasn't some mechanism by which to remove the president prior to the next election. Once the framers decided at this point that impeachment was necessary, not just for judges, but for executives, there were languages. You had to define what it was. Initially, they thought treason, bribery, and corruption. They got rid of that. They kept treason and bribery, as we know. But now you had to figure out something else. So the gentleman from Virginia added the language maladministration, which sent everybody into a tizzy because it's vague. The term is so terribly vague. Madison argued again that Congress could remove any president it wanted if it disagreed with them on the grounds of maladministration. You could just make up anything and say they're maladministering their office. So they abandoned the word maladministration, and George Mason proposed high crimes and misdemeanors. They adopted that proposal. So now we have the language inside the Constitution which says the president, vice president, and civil officers shall be removed from office on impeachment for and conviction of, and we'll see that's important in a bit, treason, bribery, or high crimes and misdemeanors. As I said, 18 times in our collective constitutional history, impeachment has been tried. 13 of them involved federal judges. What were the crimes that these judges were levied? What was levied against them as impeachable offenses? What high crimes and misdemeanors were committed by judges? Habitual drunkenness, showing favoritism on the bench, using unlawful judicial power, using the office for financial gain, unlawfully punishing people for contempt. Submitting false expense accounts was one of them. Special deals from parties appearing before the court. One judge was impeached, and one of the counts was bullying people in open court. So we've had bullying in our constitutional history as far as impeachment is concerned. Filing false income tax returns was one of the counts levied against a federal judge. Disclosing confidential information was another. There have been only 3 times where impeachment has been attempted and levied against a president. So in order to, again, look at the high crimes and misdemeanors aspect of things, I think just looking briefly at the history of those 3 might give you a sense as to what's impeachable and not, and also the control that the House of Representatives has in determining impeachment. The first president that was impeached was Andrew Johnson back in the 1860s. After Lincoln's assassination, Johnson takes over as president, and there was a group of Republicans called the Radical Republicans who supported a military rule over the southern states after the Civil War during the Reconstruction period. They wanted there to be a military presence constantly in office. Voting rights and redistribution of land for all African Americans, blacks, they wanted that. President Johnson disagreed with that. He wanted there to be a quick restoration of civilian rule in the South. These 2 sides, the radical Republicans, the Lincoln supporters, far-right radical Republicans, and Johnson went at it. they passed a law regarding Reconstruction legislation that Johnson vetoed. And Congress didn't like that. Congress overrode the veto. Congress passed what was called a Tenure of Office Act, which then required Andrew Johnson to get permission from Congress before firing anybody from the executive branch who had previously been approved by Congress. So Johnson's answer, when he was told by Congress that he couldn't fire anybody, Johnson's answer was to fire the Secretary of War, Edwin Stanton at the time, who was in fact a radical Republican. So his firing violated the Tenure of Office Act. And Johnson believed that that act was unconstitutional. So the House impeached him. They filed 11 articles of impeachment. 8 of them involved his violations of this Tenure of Office Act, which limited the president's authority. So they thought. One of them said that he sent orders through improper channels. And another accused him of conspiring against Congress, citing a statement that he made about Congress that they didn't represent all of the states. At the end of so he made it through the House of Representatives. They voted to impeach. We'll talk about how that works later. And it made it to the Senate. Only 3 of them, only 3 counts on the impeachment were brought to a vote. And Johnson was not convicted by the Senate on each of those 3 counts. He made it survived by 1 vote. Most people, in looking at Johnson's attempted impeachment and removal, look at this as being a really bad reflection on American society at the time, that none of the offenses really were technically impeachable, that this was a political argument. And we'll see how that works in a few minutes in terms of how impeachment is offered and proffered. The second attempted impeachment, I say attempted impeachment, was Richard Nixon in the 1970s. As we know from our history, Richard Nixon won the presidency in 1972 by a landslide, but he was connected to the Watergate burglary, where the Democratic National Committee's headquarters were burglarized by the Plumbers. I love that nickname. The Watergate burglary drew a very little press attention at the time, but it started a domino effect of events that ultimately wound up bringing down the Nixon presidency. Nixon may or may not have had advanced knowledge of the burglary, but he feared, however, that the investigation might disclose evidence of political spying and the illegal use of campaign funds on the part of his administration and use of authority to go after certain political enemies, the Nixon enemies list. So as part of that, President Nixon took a more active role in obstructing the investigation of his White House and his staff. He had discussed raising hush money for the burglars. He had discussed enlisting the FBI and the CIA in squelching the investigation. Starting to sound familiar? In 1974, the House Judiciary Committee voted 3 articles of impeachment. One of them accused President Nixon of obstruction of justice, another of abuse of power, and the third charged him with contempt of Congress for defying their request to produce documents. Again, starting to sound a little familiar. Before, however, the articles of impeachment were voted on in the House, President Nixon resigned before the House got a chance. Again, this more in terms of a political disagreement, Nixon's involvement may in fact have actually violated certain federal statutes. So of the 3, Nixon and Clinton, as we're about to discuss, were much closer. But notice that obstruction of justice was one of the things that was in the articles of impeachment against President Nixon. During that, however, there was a discussion, because this was as close as we had come at that point, and there was a commission on impeachment that was created during this, and they discussed the reasons for impeachment and why we should or shouldn't do it. And language directly from the commission said this: not all presidential misconduct is sufficient to constitute grounds for impeachment. That presidential impeachment is a grave step for the nation. It is predicated only upon conduct that is seriously incompatible with either the constitutional form of government or the proper performance of constitutional duties. At the same time as this commission came out, a law school professor by the name of Charles Black published a very influential book at the time, well read, called Impeachment, a Handbook. I suggest going out and reading it if you can, if you find it online. Professor Black agreed that impeachment is an extremely grave step and that it should only be taken tremendously cautiously. Because in essence, what you're doing by impeaching a president is overturning an election. Black's research in the history of impeachment led him to the conclusion that presidents should only be impeached for serious assaults on the integrity of the process of government, or for such crimes that would stain a president so as to make his continuance in office dangerous to the public order. These are questions that came up in the impeachment of President Clinton. As we all know, President Clinton, very popular professor, then a governor, then president. However, based on an Arkansas land deal that we call Whitewater, or was called Whitewater at the time, an independent counsel was appointed to investigate the land deal involving President Clinton that had taken place 20 years before his election as president. The counsel's investigation wound up getting expanded to include other scandals that had been part of the Clinton White House, the firing of White House staff in the travel office, certain misuse of FBI files, the illicit affair that the president had with Monica Lewinsky. In 1998, the independent counsel, Ken Starr, some might question his independence, but so be it, issued a report to the House Judiciary Committee. And in that report, he denoted 11 impeachable offenses, all related to the intern scandal, nothing to do with Whitewater or the travel office or anything else. It all related to the Lewinsky mess. Based on this independent investigation, the House Judiciary Committee voted 4 articles of impeachment. The first accused the president of committing perjury before a grand jury. The second charged him with perjury and false and misleading testimony in a civil case related to this, the whole deposition that we saw. The third accused the president of obstruction of justice, same as with President Nixon, to delay, impede, and cover up or conceal the existence of evidence related to the Lewinsky scandal. And the fourth charge alleged that he misused and abused his office, asserting executive privilege to hinder the investigation. As we know, he was impeached. The House of Representatives did, in fact, impeach him. But when the case went to the United States Senate, he was not tried at that point. He was tried, and based on the Senate vote, he was not removed from office. So obstruction of justice, perjury, false misleading statements, these things were used by the government to engage in impeachment. But looking at Professor Black's language, one has to question whether these are so essentially injurious to the office of president that it would stain their ability to perform going forward. So that's the when to impeach. So treason, bribery, high crimes and misdemeanors. How does one impeach a federal official? The steps are laid out in the Constitution, Article 1, Article 2, also in 3 U.S. Code, Section 19. But I want to break it down for you into the individual steps. So as we've seen in these previous investigations, first, someone in the legislature, someone in the House of Representatives makes a formal charge to the Justice Department, or an independent counsel makes a formal charge to the Justice Department, who then investigates those charges and presents them, as we saw in the Ken Starr report, presents them to the House Judiciary Committee. After that's done, the House Judiciary Committee reviews all of that evidence and they take a vote. If the House Judiciary Committee says that the evidence meets their standard of finding impeachable offenses, then the House Judiciary Committee drafts what are called articles of impeachment, stating what the individual high crimes and misdemeanors are, whether there's treason, whether there's bribery, but they lay them out as individual counts. They then present these articles of impeachment to the entire House of Representatives as a body. They are debated on, these articles are debated on, and then they're voted on. All it requires for impeachment to happen is a simple majority, just one more than half of the total amount of people that are in the House. If a simple majority of the House votes affirmatively, the president is considered impeached. That is not the end. Just because someone is impeached, as we know from President Johnson and President Clinton, just because you're impeached does not mean that you get kicked out of office. There is another group of steps that has to occur. Once a president is impeached, it gets referred to the United States Senate. The United States Senate is the trial body for an impeachment. The United States Senate, as we saw in Article 1, Section 3, is responsible for trying impeachments, and they hold a trial in the well of the Senate to determine whether the president shall be removed from office. So the House decides on impeachment, but it's the Senate that has real control over removal of the individual being sought to be impeached and removed. The House Judiciary Committee, who proposed the articles of impeachment over in the House Judiciary Committee is the prosecution. They present their evidence in the Senate against the president, if it's a president or a vice president or whoever the authority is. They are the prosecuting authority. They bring their charges and they make their case in the Senate. The president has a right to have defense counsel present, just like any other individual accused. The president can have counsel, and the trial is presided over by the Chief Justice of the United States Supreme Court, who discusses and addresses admissibility of evidence. They make rulings just like any judge would do. Ultimately, the prosecutor, the House Judiciary Committee, versus the president and his counsel, the Chief Justice of the Supreme Court sits as a trial judge, and the United States Senate is the jury. After the trial, whenever the trial is concluded, however long it takes, a 2/3 majority of the United States Senate, so which we know there are 100 members of the United States Senate, a 2/3 majority, 67 senators, must vote against the accused official in order to remove them from office. So the impeachment comes in the House. The trial related to removal from office comes in the Senate. And only a 2/3 vote in the Senate will result in removal of that individual from their elected or appointed office. Is impeachment the only way to remove a president, or in this case, a president, from office? Is there another way? Yes, there is. But it is daunting, to say the least. The 25th Amendment to the United States Constitution addresses the succession of authority to the presidency, but it also addresses the inability of the president to perform their office. The 25th Amendment allows for the removal of the president if the vice president and a majority of the cabinet informs the Congress that the president is unable to discharge the powers and duties of his office. At that point, the vice president steps into the president's role. The president can send a letter to the Senate saying, I'm not unable to perform my office, I can do that. And then they put the president right back into office. And then it would require the vice president and either a majority of the cabinet or, again, 2/3 of both houses of Congress to confirm what the cabinet said in order to remove the president. So in essence, there's another vote that would take place. And now it's 2/3 of both the House, not just 2/3 of the total, 2/3 of the House of Representatives and 2/3 of the Senate would have to agree that the president is unable to discharge the powers and duties of the office. And at that point, the vice president steps in and acts as acting president until that disability or removal is terminated. What happens if the president's impeached? If the president dies, again, this is addressed in Article 2. This is addressed in the 25th Amendment as well. If the president dies, resigns, or is otherwise ineligible, the vice president steps in. The vice president then can nominate a new vice president to sit in their old seat, and that gets approved by Congress. If both the president and the vice president are removed, then the line of succession goes as follows. First, it goes to the Speaker of the House. So in this case, if President Trump and Vice President Pence were both removed from office for whatever reason, then the Speaker of the House, Paul Ryan, steps in as the president. If Paul Ryan is not able or suited or is removed for some reason, then the progression goes to the President pro tem of the Senate. In this case, that would be Orrin Hatch from Utah. Imagine that. And then it progresses through a number of the secretaries, the cabinet offices, Secretary of State, Treasury, Defense, the Attorney General, the Secretary of the Interior, Agriculture, Commerce, Labor, Health and Human Services, Housing and Urban Development, Transportation, Energy, Education, way down at the end, Veterans Affairs, and the Secretary of Homeland Security is the last ditch in terms of available people to step in if a president and vice president and everybody else before them has been removed. That's how to impeach a president. So we've talked about the when you can in terms of treason, bribery, or high crimes and misdemeanors. We've talked about the how to do it. Now I got to tell you why it's not going to happen. And this is where I'm trying not to opine and give my opinion, but these are simply facts related to impeachment. You made it this far. Stick with me for a few more minutes. And again, if there are questions, bring them. I'd be happy to try to answer them. Here's why none of all of what I just discussed is going to happen based on the current composition of our government. Right now in the United States House of Representatives, we have 241 Republicans and we have 194 Democrats. In the United States Senate, we have 52 Republicans and we have 48 Democrats. The United States Supreme Court Chief Justice John Roberts was appointed by President George W. Bush, our Republican president. The current composition of the court is 4-4 and 1 in the middle, Anthony Kennedy being a moderate conservative. 227 years we've been going at it. 44, now 45 presidents. 2 actual impeachments in all that time. And in both of those impeachments, there was no conviction. The only reason Bill Clinton was not removed from office in just as vitriolic a climate as during the Whitewater days as we have now is because the Senate, who's ultimately responsible for removal, is voting along party lines. If you sincerely believe that in this particular current political climate, with all of the partisan intransigence on both sides of the aisle, that the House Judiciary Committee, with a majority of Republicans on the House Judiciary Committee, they're going to push party aside and they're going to jump ship and draft articles of impeachment. Then you're going to expect that 24 Republicans are going to jump ship and join all of the Democrats to vote to impeach. Then you get an impeachment. That's what all of the let's impeach him now. But that's what you need right now to get an impeachment. But an impeachment, as I said, means nothing in terms of removing the person from office. You then have to remove him from office. So there's the daunting issue as far as whether you can impeach him or not. Assume, for our argument's sake, that you can get the House Judiciary Committee to vote articles. Assume that you can get 24 Republicans to jump ship. And hey, maybe they jumped ship as far as the healthcare. People jumped. They did. But frankly, this is a little more serious than healthcare. This is altering the structure of government. This is overturning an election. And I really doubt that you're going to get 24 Republicans to jump ship. Assume that they will. Now you've got an impeachment. What's next? As we just discussed, it's not just an impeachment. You have to remove the person from office. So now what you need is to get 19 senators, 19 Republican senators, to do the same, to jump ship and vote to convict the president on this and to vote to remove him from office. If you think that all of that is going to happen in this particular climate, God bless you. It just understand through all of this, impeachment is not a legal act. It doesn't foreclose impeachment. The possibility or removal doesn't foreclose the possibility of pursuing the president in criminal court for certain actions, for civil actions. You're going to address executive privilege at that point, and that's a whole nother ChrisChat for a whole nother day, executive privilege. But what you're looking at is not necessarily a legal or constitutional act, but a political act. And in this climate, right now, this political act is unlikely to happen. What do you do then? Are you screwed? No. Be vigilant. Continue to be vigilant. Yes. Hold people accountable. Wave your constitutions at them. Again, continue to understand what's going on. If you want one, come get one. I'll be happy to give one to you. Free, no charge. Message me. I'll send one out to you. Read it. It's quick. Be vigilant. Absolutely. Be strong in standing up to authority. Yes. Be strong to fight against the stripping away of your individual freedoms when they are threatened. Yes, do that. Question authority. Absolutely question authority. But please, focus your efforts on the actual. Focus your efforts on local elections every single year. Focus on getting people that hold your viewpoints and that will represent you at the local level. School committee, selectmen, planning and zoning. You might think that they are stupid, useless elections, and the voting turnout proves this. But this is where incursions are made. And this is where government builds from the lowest blocks. Go into a local election every single year. And then every time a federal election comes around, starting in 2018, get involved. Not just when, not only in elections where someone shows up that lights your world on fire and energizes voters. You got the Bernie folks here, you got the Hillary folks over there, Trump here, Cruz there. Get involved every year. Find someone. And if you can't find someone, make someone. Do that. Be involved. Can you impeach him? Maybe. Are you going to remove him from office right now? There's a lot of work there, and I really don't see it. I really don't. That's what I've got for you. I apologize for the soft ending, but I want you to focus your energy and your intention on things that you can change. Do that. If you want to check these things out and look up the rules of succession and look all of this up, like I said, as I say all the time, this is here waiting for you. Send me a message and I'll be happy to send one of these out to you directly. Read Article 1. Read Article 2. Read the 25th Amendment. Go through all of these things. Go into the United States Code, 3 U.S.C. 19. It lists out all of the requirements for this. Don't be afraid to look these things up yourself. But if you have questions, ask. Please do, because this stuff is too important. And more important than that is devoting energies towards making real change and not necessarily in attempting change that, for all intents and purposes, may not be successful and simply plays into the hands of those who want to put you in a box and say, this is the type of person that these people are. Work hard, be vigilant, stay strong, keep up the fight on both sides of the aisle. But recognize that impeachment might seem easy, but it is not. 227 years. Twice. It just doesn't work. That's all I have. If you have any questions, I'll be happy to stick around. Otherwise, if you have questions after the fact, by all means, post them here and I'll attempt to answer them down the road. But as always, my name is Christopher DiOrio, and this has been ChrisChat.